Recording. Hi, everybody. Welcome to Trial Alchemy. And today I'm delighted to have as my guest Craig Peters from up in San Francisco. Craig is the founding partner of Altair Law in San Francisco. He's a plaintiff's lawyer, and he handles high-value personal injury and wrongful death cases, and also co-counsels as trial counsel on cases as diverse as civil rights, consumer rights, landlord-tenant disputes, business disputes, toxic exposures, and insurance bad faith and medical malpractice. And Craig and his team have achieved some of the largest verdicts and settlements in California, and in some cases, the entire United States. Craig is a member of the American Board of Trial Advocates. He actually currently serves as the National Treasurer of ABOTA, and he also serves on the National ABOTA Board of Directors. Craig is also a member of invitation-only groups, including the American College of Trial Lawyers, the International Academy of Trial Lawyers, and the International Society of Barristers. Craig has served in other legal organizations, including serving as the president of the Consumer Attorneys of California in 2021 and 2022 that year. And Craig has won numerous awards for his work as a trial lawyer. He was the Consumer Attorneys of California Trial Lawyer of the Year in 2018. And for several different years, he's been either a Trial Lawyer of the Year finalist or a Consumer Attorney of the Year finalist for these different groups: Consumer Attorneys of California, San Francisco Trial Lawyers Association, and the Marin County Trial Lawyers Association. So without any further ado, Craig, thanks for being a guest here today. I'm delighted to have you.
Thanks for having me on, Monty. I appreciate it. Look forward to talking to you.
Yeah. Well, let's jump right in. And the first thing I want to ask you about is you've tried a lot of cases and got a lot of great results. Tell me about one of your most satisfying trial victories. Could be more than one if you want.
I think so. It's hard for me to pick. I'd say that it's kind of between two. It's one that actually was one of the last cases I tried, and the first civil case I ever tried. So I'll go with the first civil case I ever tried. I had just switched over from doing criminal defense work for 13 years.
You were a public defender for many years.
That's right. I was a public defender for 13 years. 3.5 of those years, I was the director of training for the San Francisco office, which was a great job, working with other attorneys on trial skills and developing themes and theories for their case and litigation plans. A lot of that translated over, even more so than I thought it would, to doing civil work. And I was fortunate when I moved over to civil work. And the reason I did move over to civil work, I ultimately was because there was a firm that was looking for somebody to just try cases. And so I started working for a firm called Paul and Hanley. They do asbestos cases, plaintiff side. They're in Northern California, but all of their cases were generally in one of three venues: Los Angeles, San Francisco, or Alameda. And they had two, at the time they had two trial attorneys. Their plan was to go to stay with two, but I had become the third. One of the other two was going to be taken out of the rotation. And they said, don't worry, this is mostly science. And, and we kind of have a playbook down for how these cases go. And they're, we know these jurisdictions like the back of our hand, and the judges there know us. And so, take 6 months. We're going to send you to some trials. You won't have to try anything. You just sit and watch. You can kind of absorb the science, and then we'll get you up and trying cases. So 2.5 months into it, they had this one oddball case in San Diego, a jurisdiction they were never in, that had no standard, what I later came to know is sort of the standard playbook, if you will. Every case is different because every client is different, but
right.
The science, generally speaking, it comes from one of 100 products, and those 100 products can generally be categorized into like 3 or 4 general categories. And so there is a little bit of a routine, maybe is overstating it, but
right.
There's a comfort level each time. So this case was this kind of crazy one-off case. It was a construction work site where they did staging, And there was a guy who lived on site in a trailer.
Hmm.
So he'd watch the stuff at night to make sure nobody broke in. It was a really big yard. And on, I think it was Thursday nights, he would have these barbecues at the site at night, and his friends would come. And they'd have a big, they were mostly Latino, mostly Mexican. And they'd have these big barbecues. And they'd play music, etc. And one of the areas where they sat was the edge of one of these kind of dump areas that had a bunch of old broken pipe.
Oh my goodness.
That old broken pipe was sewer pipe that had asbestos in it.
Mm.
So one of those people was our client. And so kind of low exposure case. Again, that's sort of not the norm. Real hard to quantify. He wasn't actually cutting pipe or breaking pipe. He was just sitting on pipe at night.
Yeah.
So it really didn't fit. And then, of course, on the defense side, it was this construction company. They weren't used to asbestos cases. So kind of nobody except for the pipe manufacturer and a few others were sort of used to the asbestos world. And then there was the rest of us. And it just turned out to be a great experience all the way around. I got to know the defense attorneys and mostly got along with them, particularly the ones who were also kind of learning as we went along through the trial. We were in front of Judge Taylor, who
Tim Taylor.
Yeah, and I think he's like some of our judges up here. Judge McBride kind of comes to mind, where people have real strong feelings one way or the other about him.
Exactly. You were on Taylor time.
Yeah, and he was a hard ass, but he was a hard ass because what I came to appreciate was it's because he really had a great reverence for the legal system,
right,
for the process, for the jurors.
Right.
And he wanted people to see that the trains run on time, and it's not just efficient, but it's fair.
He really cares.
He really does care. Yeah, and he's a bit of a character. Wears a bow tie, and
right.
He has this persona for sure. And I remember sitting in his chambers, and we were asking one of the defense, and there was like, I don't know, 7 or 8, I can't remember how many defense attorneys on the other side. And keep in mind this, I walk into the courtroom and I went and sat at the wrong table because I'm so used to sitting at the defense table because I was a criminal defense attorney. And there was and I had never used a jury consultant before. And the attorney who was supposed to have this case had gotten a jury consultant for the case. Her name was Carol Baus. I still use Carol to this day from the National Jury Project. And so Carol was there, and she's like, no, wrong. We're over here. I'm like, oh, right. Yeah, we get to sit the one. That's great. So, I sit there, and then it's just, the two of us sitting at this table, and there's, the table's not big enough on the other side. They're trying to arrange chairs. So everybody has a little spot. And anyhow, we go back in the chambers, and one of the defense attorneys asked about voir dire, and Judge Taylor says, well, as you know, it'll probably take us 2 days to do voir dire. And then, we'll get a jury in no time flat. And I was thinking to myself, because I was used to, I'd done an 18 pack, I'd done a 24 pack. And I was trying to think to myself, what exactly is he talking about? So, being sort of sheepish and apparently not having read his court rules, nobody telling me there were court rules, because again, not something I was used to in the criminal defense world. And I sort of said, Judge, sorry, can I just get clarification? He says, yeah, you're going to voir dire. We're going to have 82 people in here. And they're all going to sit in order from seat number 1 in the jury box to seat number 82 in the back of the audience. They'll all be in order, and you're going to voir dire all of them at one time. I'll give you as much time as you need to do that. But it shouldn't take us more than 2 days. And then we'll do cause challenges and then do peremptories, and we'll be done. And I was like, that sounds impossible. And it ended up being, I sort of felt like Phil Donahue, with this microphone and then passing it around. And I came to love it. And I actually advocate for it now in cases that I think it is such. One, it engages every single potential juror in the process, which I think makes jury service more meaningful. We always think the way we help jurors is just get them out of there quickly. But I'm not sure that it's, the quote unquote wasting their time that's such a problem. That's the perception that their time is being wasted because nobody ever bothers to ask them, well, what do you think about this? But if they're asked, what do you think about this? I don't think it feels like a waste of time if they're part of the process. So I thought purely from a PR standpoint, for the judicial system, I think it makes a lot of sense to do voir dire that way. And then just the rapidity with which you then end up getting a jury, right? Because you do your cause challenges, and now
Right.
there's no round two. You do one
No,
round.
right. Get it
And
all
it's
at once.
right. And it takes longer up front, but it's so much faster on the back end. And I hope, the potential jurors that don't get picked end up walking away feeling like, that was kind of an interesting process. I learned a little something. I got to share my opinion. So anyhow, so that was a super memorable case, in part because it was my first case, in part because it wasn't following any of the regular rules, and so the home office back in Alameda was like zero help. They're like, I don't even know what you do with this case. Just go for it, Craig. Do your best. Kind of learning the science as I went along. But yeah, it was a really entertaining. Obviously, to this day, I still remember. That was in. That would have been in 1999, I want to say, or 2000. No, sorry, 2009 or 2010.
Yeah, that's a good time frame. Yeah.
Yeah, 2009 or 2010. So it was great. It was, and I went to undergrad at UC San Diego. So it was also kind of fun to just be back in my, once I kind of got over the nerves of, oh my gosh, I'm about to try a civil case, and I go first, and, I don't really know what I'm doing, or don't feel like I know what I'm doing. It sort of took me back to my early years of being a public defender, where you just walk into court and you just had to have a lot of moxie and, kind of fake it till you make it.
I had a similar experience where I'd been doing plaintiffs med mal work for a long time. And then I got asked by this doctor whose wife was an administrative law judge who I tried some medical board cases in front of to defend him. And so I'm talking with a defense lawyer saying, hey, I'm going to represent this doctor. I tell him, I'm going to forget where to sit. I'm used to being on the plaintiff side. Yeah. I'm going to forget I go second.
Right.
So it can be pretty funny.
Yeah.
Sure. So did you have another one you wanted to share? Or is that the one you wanted to share?
That's probably, I don't know. I'm not sure. How much do people really like war stories beyond the person who's telling them?
No, well, that's great. And you got a great trial judge with Judge Taylor. Now, you're a member of ABOTA and you're actively involved with the national board and all that. Let me ask you this question, at least as to you, why is ABOTA important to you?
It is one of the few organizations out there that actually advocate on behalf of the rule of law and the independence of the judiciary, which
right.
I would hesitate there a little bit, because I think that sometimes we say independence of the judiciary and that sounds very absolute, and it's not complete independence, but it's independence in the sense that, where they can make decisions based on the law, free from, the
politics or pressure.
Yeah.
Yeah, we want them to make fair and impartial decisions consistent with the law. That's what we want.
Yeah.
Yeah.
Yeah. And having an organization that's got, defense attorneys and plaintiffs attorneys, it has them, I'd say the vast majority are doing some kind of personal injury plaintiff work or defense work on the insurance side. There are others that are doing business cases and other types of cases. And so there's a degree of credibility that ABOTA has that some of the other organizations that are all defense or all plaintiff may not carry quite as with as much heft and influence. And so that's my appreciation. And ultimately, ABOTA, aside from that piece, which is, maybe kind of 30,000 feet macro level, at the micro level, there also is nobody else out there that is advocating for civility in the practice of law like ABOTA is. And as our political discourse gets harsher and cruder, more divisive, I think it's important that there's some organization out there that is trying to be the bulwark against that happening in the legal profession. And that's not to say it hasn't. It's there for sure. In fact, one of the great ironies of having moved from criminal law to civil law was I used to joke that the criminal lawyers are a lot more civil than the civil lawyers are.
That's what I've heard.
And that's borne out just by virtue of, you see the same people all the time. So there might have been district attorneys that I didn't particularly care for or see eye to eye with, but but I respected them and I was courteous to them, and they were to me as well, because we see each other every day, and you got to maintain some kind of relationship. You can keep your principles and your morals and your ethics,
right,
and still be civil. Those are not mutually exclusive ideas.
Right. That's very important. Very important. So let me ask you about this. When you're getting ready for a trial and you have tried a lot of cases, do you have a process that you've developed for your final prep time? Maybe the month before, a couple months, whatever it is. And in general, what is that approach? How do you get ready so you are ready to go when it's time to start?
Yeah, I do. And I'd like to tell you that I finally got to the point where like I should sit down and figure this out and write it out. And that's not at all how it happened. It just kind of evolved over time through luck, I guess. But what I learned, one of the things that translates really well from criminal law to civil law is that, at the end of the day, the only thing that matters is your jury. We think the facts matter and the graphics matter and the judge matters. Those all do matter, but not in the same way that the jury matters. And certainly those things may have an impact or influence on the jury.
Right.
But from my perspective, and one of the things I was teaching when I was at the public defender's office, and then got a little bit away from when I started doing civil because it felt like a different world, and then ultimately kind of circled back to it, was I need to start from the perspective of the jurors. And my experience has been and continues to be that the best place to start to get to that perspective of the jurors is start with a verdict form. Everybody wants to do the verdict form last. I can't tell you how many times I go in for, pretrial conference or trial readiness or whatever, and the judge has a whole list of things she wants. She wants, your witness list and exhibits. Right. And I'll always bring up verdict form, and frequently I'll get like, well, we've got time for that. We're not sure what the evidence will be. I'm like, let me just be clear. I used to do criminal defense cases. Nobody gets deposed, and yet we still knew what the ultimate questions were going to be on the jury form. Here we've got depositions. Of course we know what questions are going to be on the jury form. Let's get it done now so that we can use that as the frame through which we see all of the evidence that's coming in. I think it's not only helpful, incredibly helpful for us as lawyers, but it's also helpful for the judge. But forget about those two parties. Most importantly, it's important for the jury. And so if we're not spending our time focused on that at the beginning, I think then we don't come off as organized and as concise as we could to help the jurors get to the right answer. So I start with a verdict form. I try to, think about it with the plaintiff's hat and a defense hat on, try to finalize that. And then I think about my evidence and I say, where does my evidence go? What are all the pieces of evidence I need to support a yes answer to question one? What is all the evidence I need to support a yes answer to question two? And then I say, and now, once I've done that process, I'll go through and do the flip side. What is the defense going to say? How are they going to try to undermine those things? And then what's my rebuttal going to be? So I basically have an outline inside of my verdict form of the evidence that I believe I need to prove my case. And in an ideal situation where I've got a second chair or somebody else with me, ideally, most ideally would be like a law student. Their job is to sit there with that piece of paper and check those items off when they come into evidence. And then I'll annotate those items with my physical evidence that I'm bringing in as well. So I'll have, I basically have created a checklist. And now I can use that in closing argument. And here's the other great thing about that. And again, this came from my public defender days. No trial lawyer, I think, ever contemplates getting hit by a bus.
No.
But you could get hit by a bus just like anybody else.
That's true, in the middle of trial.
If you have an organization to your case, nearly anybody, like in the scenario I just laid out for you, right? Have a verdict form, somebody's checked off all the boxes. really anybody could get up and give that closing argument. They know what's in evidence because they've got my outline.
Right.
So that's my technique that I have found the other thing it does is it tells you where your soft spots are. You
Right.
immediately go like, wow, that's all the evidence I have on that. I maybe need to do a little more digging. And ideally I'll do that, far enough ahead of trial. I'm still in fact discovery while I'm doing this process. But I've actually done it as early as before I've even filed the case. I come up with my verdict form and start saying, what is the evidence I want to have in a case like this?
Well,
And
that's what I was going to say. A lot of great trial lawyers, and I've done this over the years, have said, look at the verdict form, or figure out the verdict form and the jury instructions you're going to use at the beginning. And that's how you start to figure out, okay, what evidence do I need? Do your discovery, get things worked up. And the same thing as you're saying, when you're doing your final prep, that's what you should do. And that's a great tip there. And I like the idea. I use checklists in a lot of ways, but using a checklist approach was saying, hey, here's what we have to prove with the verdict form. And boom, we got to make sure we got everything in. That's great because you can miss stuff. That's a problem if you don't use a checklist. You're going to forget something and you don't realize you missed it. And then, man, you're in trouble if that happens.
right. And when I train younger attorneys or attorneys who haven't tried a lot of cases, I was asking them, did you take high school chemistry? And they say, yeah, I took high school chemistry. Okay, tell me 5 elements from the periodic table. And most people can't do it.
Right.
Or if they can just barely do it. And I say, okay, when was the last time you told the story of the 3 bears? And I'm like, God, I don't know, when my kid was little, probably 35, 40 years ago. Okay, tell me the story of the 3 bears. Everybody can tell you the story of the 3 bears. Why is it?
Yep.
Because our brains think in stories. They don't think in checklists.
Right.
So the law requires, if you go up on appeal or whatever, that you've checked certain boxes, but that will never win the case for you. So you need to have some system where you make sure you've got all those items that then frees you so that you can tell the story.
Well, that's another thing, and that's an important point because I actually got to sit on 2 criminal cases as a juror. I was shocked, 2003 and 2006. And my experience, I was really impressed by the jurors in both cases. But my experience is they don't think like we do as lawyers and judges. They don't analyze it like we do, and we obsess over it, trying to get the verdict form and all that. But they want to do the right thing, and they usually figure it out. But the way you got to tell them is with the story, and you got to tell them by making the case something about a moral or a value or a right or wrong, so it's understandable. So you got to take all that checklist stuff you got to cover for the law, but you got to tell that compelling story to persuade your jury, right?
Right. That's right. And and to the extent you can take that checklist and just make it a thing that somebody else is taking care of that then frees you to tell the story, I think, at least in my experience, that the better off you are.
Oh, yeah.
The more successful you'll be.
Yeah. Well, let's go next to the idea of trial themes. Now, you may use similar themes in a lot of your cases, but you may mix it up. So what are some trial themes that you have found work really well for you?
Yeah, so I used to be huge on, coming up with themes and slogans for my cases, particularly back when I was a criminal defense lawyer. I've done it a lot as a plaintiff's lawyer as well. I do it less now than I used to in terms of having, something catchy.
Well, good. Explain why too. Yeah.
Sure. Yeah. Profits over people is always a good theme if it's applicable. And certainly that may come out during the trial if I do a lot of products cases. And so that's a frequent area in which that will come out.
Right.
I like to say that, a trial isn't about the facts. The jury, again, if we sort of think about the case from their perspective, you've pulled 12 people in from the street and stuck them in a box inside of a courtroom that's this kind of intimidating place.
Right.
And then a bunch of orders and rules have been barked at them, most of which they're not really digesting yet because they're still thinking about their family, their work, their, boyfriend, whatever.
Exactly.
And And then the lawyers get up and give these amazing opening statements, that tell them that, this is a roadmap and, this is what you're going to hear. And then give them, 1,000 facts for the plaintiff and 1,000 facts for the defendant. And then they proceed to have a trial where witnesses go on and tell them information. Sometimes it seems maybe like it's related to the opening statement, but maybe it's not.
Yeah.
Right. They're not really sure. And they're trying to take notes, but they don't really know. It's kind of like you've handed them a basketball on a basketball court and said, play basketball, but you haven't told them what any of the rules are or how you score, right? They don't know any of that stuff.
Good
and
point.
we forget that sometimes because we're so used to it. And so, the beauty of themes and slogans is it creates an anchor that, the jury can be tied to again and again and again that helps them remember what the case is about. That's super useful. But the case isn't really about the facts because they don't know what facts are important or not unless you have a judge that at the very beginning gives them the jury instructions for the elements that have to be proven so that they now are oriented to what they need to know, which, by the way, I advocate for. I think that makes a lot of sense. It's a lot more fair to the jurors to do that, but that's not the norm, at least in California.
Right. You don't get a lot of judges saying yes to that.
No, and it's odd to me because it just makes such fundamental sense. But in any case, it's that's not the norm. So if the case isn't about the facts, then what's it about? It's ultimately about who can the jury trust. They are looking for somebody to trust in the courtroom.
Right.
They will trust the judge, no matter how good or how bad the judge is. My experience has been they will trust the judge, but the judge isn't giving them facts or making a case for one side or the other. So I feel like our job as the lawyers is to be, despite what you see in politics these days, where a politician can say the same lie 50 times and get called out on it 50 times and keep saying it and people will believe it. That's not how it works in a courtroom.
Right.
In a courtroom, if you lose credibility once, enough jurors are going to know that they're going to start to discredit what you have to say. So our job as lawyers in a trial is to build our credibility with the jury so that they know that we are an honest broker that they can trust. Sometimes I think themes and theories and slogans can get in the way of that. And so I have moderated my approach somewhat, that if I'm going to use one, I might use one once in opening, and I might use it again a couple of times during my case, but I won't beat the drum like I used to with a theme or theory or a slogan, because I think it actually can be counterproductive to building that trust with the jury. I am a big believer. One of the big things I learned as a public defender, was about bad facts. Turns out as a public defender, you sometimes will get cases that have bad facts.
Amazing.
In fact, every case has a bad fact, which is that your client has been arrested and charged with a crime.
Yeah.
And jurors tend to think that means something happened. And our motto in the public defender's office, when we talk about cases and, what are the facts and how we're going to deal with them, was whatever our bad facts are like bad fashion. Don't try to hide it. Feature it. You got a bright neon pink boa. Don't try and tuck it under your jacket. Wear it right out there. Put it right out front. Right. Because if you put out front the bad facts, it does two things. One, it takes the sting out of it. It doesn't appear to be as bad because you, the person who it presumably is harmful for, is the one that's bringing it to the jury.
And you're not trying to hide it.
You're not trying to hide it. And number two, it tells them you are an honest broker. Yep. You are not going to try and shade the truth or hide things from them or skirt issues or avoid issues. You'll deal with it all, because ultimately you're not only telling them you can trust me, what you're telling them is I, the trial attorney, I trust you. And so, themes and theories are good. I think they're a good way to think about your case, to kind of crystallize in your own head what the case is really about.
Right.
But I spend less time with them now than I used to, particularly in weaving them through my cases, because I'm more focused on figuring out ways to earn the trust of the jurors through the course of the trial.
Well, I think that's a really good evolution in your thinking. I mean, in my experience in trying cases just like yours, credibility is the most important thing. Totally. And as you say, the judge will be presiding and they trust the judge, but they're going to have to believe one of those attorneys. And if they don't believe you or they don't believe your client, you're in big trouble. So I've always thought credibility is the most important thing. And it's not just being, I think it's not just being honest and being straight with them. There's also a likability component. So that if you're honest and straight with them, but if you're I mean, this is the ABOTA thing. If you're a professional, courteous person, and your opponent is not, and so often that's true too, that helps your credibility.
That's right.
Just being courteous and just being respectful, that kind of stuff. I mean, I had one
patient.
Yeah, and you got to be patient. I mean, I had one of my thoughts that I always used to have in trying cases was, well, nobody's going to ever out nice me. At the worst, it'll be a draw. But if they're not able to be polite and courteous, that's going to help my credibility.
Mm-hmm.
And I think it really does. So I think that's a great insight. And so you don't use the themes as much. You may still use them a little bit, but not as much. That's great. Yeah. So I think I know what your answer is going to be, but I'm going to ask you what part of a jury trial is, in your opinion, the most important and why?
Voir dire.
Okay. And why is it so important? Because the jury is important, but tell me more about it.
Yeah, I mean, it's in my mind, it's the whole, there's some people out there, there's an adage that, the case is over after you've picked a jury. And that might be a bit of an overstatement, but I don't think it's too far from true. Being able to really probe into how your jurors think, what their attitudes are towards certain topics. I would, I tried over the last year and a half. I tried one case. I tried a civil rights case where the judge gave me 8 hours to put on my case. There were 7 officers at the scene. I had 3 women who were my clients.
8 hours. That's pretty
Gave
fast.
me 8 hours. Gave me 8 hours. Yeah.
Wow.
And that didn't seem fair. It was a federal court judge, and there's not a whole lot you can do when you got a federal court judge that's not being fair.
Right.
But I said to him, I said, Judge, I don't think I can put on my case. I can fairly put on my case in 8 hours. But I tell you what, if you give me an unlimited amount of time to voir dire the jurors, I'll get it done in 8 hours. You put whatever restrictions you want on me as it relates to the evidence, but give me the time to understand who the potential jurors are so I know how they think. I don't want yes/no questions. A yes/no answer doesn't help me.
Yeah.
It doesn't help me understand, are you racist? Yes. Nobody says that, right?
No.
I need to get at whether they, and actually in that case, I did get, so anyhow, he gave me 15 minutes, which, super generous for a federal judge, gave me 15 minutes for voir dire.
What a kind-hearted judge.
Oh, such a kind-hearted guy. But so you have to really, and I do understand the resistance by judges to giving too much time for voir dire, particularly having watched some voir dire where lawyers will kind of meander about and they sort of go over stuff that's already been gone over. Pardon me, but we shouldn't be legislating for the lowest common denominator, and we shouldn't be making up court rules for the lowest common denominator.
Right.
Which, you get what you expect. And so if we expect more of lawyers, I think ultimately we'll get more from lawyers. And look, there's a lot of new lawyers out there who want to try cases. And you know how good they're going to be the first time out? About as good as they were at playing the saxophone or running track or doing the tango, right? Like, you don't just come out a fully formed trial lawyer. It takes work. And judges need to be patient. Sorry?
You're always bad at the start.
Yeah, well, and yeah. And I think, okay, that's fair. But let's not just say, I mean, look, I've seen lots and lots and lots of attorneys that are really bad at direct exam. I've seen even more attorneys that are really bad at cross exam. I've never seen a judge say, I'm going to limit your cross exam or I'm going to limit your direct, right? But somehow that's okay in voir dire, which arguably is the most important part. So I want to know who my jurors are. If I have a good sense of who my jurors are, then it makes the whole rest of the case a much easier lift, and usually means I can put in my case more efficiently.
Right. But now, and I agree with you. I think that if a trial judge should care about the jurors doing the right thing and having a just result, and you can't get that in a 15-minute voir dire by each lawyer. All you get is a bunch of surfacey crap, and you don't really get to know them and know what their real biases. And everybody's got good and bad biases, so you don't know what they are, and you need to understand that if you're gonna try to figure out, are you a good person for this particular case? So how do you try in voir dire, and what do you do to get to know the jurors, to see if you can get people off for cause so you don't have to use all your peremptories so fast? What are you doing in your discussions? How are you trying to learn out about who they really are?
I have found, for me at least, the most effective way is to take the same approach that I take to the body of the trial, which is I just try to be honest with them.
Mm-hmm.
I can't think of any friends I have who would say, I am biased against fill in a blank, some protected class, right? I just don't think I have any friends that would say that.
Right.
Are they biased? Yeah, I'm sure they are. I have some biases, right? And I think that's a really important actual first step in doing a good voir dire, is to sit with yourself about what are your own biases about people.
Yep.
And how do those affect you and the way you think about the world?
Mm-hmm.
And what you may find in there is that you find some good examples. And as an example of that example, when I was sitting, I was thinking about some of the biases I have against people, who kind of work the land as like cowboys or ranchers. Why do I have that bias? Because my uncle is a cowboy, my dad's brother.
Mm-hmm.
I love my Uncle Kirk. He's a great guy, but he can be real stubborn and real fixed in his ways. And I attribute that to the work that he does. And I recognize that that's unfair, because there are probably plenty of ranchers and farmers and cowboys out there that aren't like that, right? But that's
right.
That's the only cowboy I know is my uncle. I don't know any others. That's not the world I grew up in. And, in talking, particularly in my younger years as a lawyer, about what I was doing, he had some real strong opinions about lawsuits and whether people should be allowed to bring lawsuits or not. And so the goal number one of voir dire for me is that the jurors are talking and I'm not. And that's real hard for lawyers, because we want to yammer and yammer. I mean, look, we were already, probably 40 or so minutes into this, just yammering away. So that's the first step, is trying to figure out a way to put a period on a sentence and no more words come after it. And so one of the ways I've done that is that I will front load my voir dire to talk about, you've heard about bias. Bias is kind of a strong word for what really we're talking about is a leaning. If I was asked to be a judge of a cookie eating contest, I would not be a good judge, because I'm biased. Not really biased in the traditional way, but I love peanut butter and I'm just not a huge fan of chocolate. So somebody can make the world's greatest chocolate chip cookie and they're probably not going to win if there's a peanut butter cookie there, right? And I know that about myself, so I probably just shouldn't be a judge. Now, if it's a pie eating contest, I kind of like all pie the same. I'd probably be a pretty good judge there. Just not with cookies, of course, unless it's a peanut butter pie. That would be the exception.
There you go.
I have an uncle who does not think that when people get hurt, that they should file a lawsuit. That this is the land of the West. We pull ourselves up by our bootstraps. Lawsuits is just a bunch of highfalutin stuff, and people should just take care of themselves and move on. Sometimes bad things happen to good people. Who here feels like my uncle? and I love my uncle. He's a great guy. I need to give them permission to tell me the truth.
Yep.
Right. And I can't do that. And I don't love using my uncle because I'm not talking bad about him, or at least I hope it doesn't come off that way, but it could feel that way. But I want to use him as an example of this duality that we can have where somebody may not be good for a case, but we can love them nonetheless.
Right. That's a great example you gave there. Yeah. And you just want to find the right juror. So you have that conversation, you let them talk as much as possible. And are you doing anything in your voir dire to try to give you an opportunity to get people that aren't going to be good jurors off for cause, so you still have some peremptories? And if so, what do you do with that? How do you try to accomplish that?
So I also am big in telling the jurors, all we can ask of you is to be honest. And if you're honest with us, we're not going to try to ask you to not be honest. And the reason I tell them that is because frequently the other side will ask them to change their mind about their honesty. Or even worse, the judge may ask that person to change their mind about their honesty.
Oh, yeah.
You told me this, but if I instruct you, blah, 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 you'd follow my instructions, right? It's like, come on, judge. We just had a whole conversation. I mean, are we asking them to be honest with us, or just whether they're going to listen to you and tell you what you want to hear? I mean, which thing are we doing here? Just tell me now. So I will follow up with some, depending on the judge I have. You know, I try to get a sense of the judge pretty early on as to what she or he is going to do as it relates to these. Once I feel like I've got, I've got enough for a cause challenge. If they, they really want me to, hammer all the nails into the coffin, they'll say, sounds like you've had this, you felt this way for a long time. Nobody could talk you out of that feeling, could they? And it wouldn't be fair for somebody to talk you out of that feeling, would it? And would you agree with me that while this case has that issue that you have a strong feeling about, you might be a really good juror on another case that doesn't have that issue? And now, sure, the other side can come up, yeah, but couldn't you blah, blah, blah. But the case law is pretty clear that should be enough for that person to be excused for cause. And, when people are telling us the truth about how they feel and how they see the world, it is a bad look for the judicial system to do anything to try to talk them out of it. I get it that sometimes people say anything to get off jury duty. We know those people. I think both the defense and the plaintiff side could usually agree on who those people are.
Right.
The vast majority, 95% of the jurors, when they tell us something that either I don't want to hear or the defense doesn't want to hear, they're simply telling us their truth. And we should take them at their word, and we should honor their word, because then they have a respect for the system. I mean, some of the lack of confidence in our judicial system is on the judicial system. We have not, I've long advocated there should be an allocation from the legislature to the judiciary to have their own PR department that does a Schoolhouse Rock kind of something PR that helps people remind people that, the judiciary isn't the tyranny of the majority. It's about rights and protecting people's rights and those sorts of things.
Right.
But within each courtroom, judges could do a much better job, I think, of helping to build that confidence. Because I know you've had this experience, Monty, at the end of a trial, you talk to those jurors.
Yeah.
It's so rare you get a juror who's like, man, I wish I didn't sit on this jury. Almost all of them are really grateful they got to sit on the jury.
Yeah, in my experience, they may not want to serve when they get the summons, and they may not want to serve when they get to the courtroom if they arrive, if they come. A lot don't. But once they're seated and started to ask questions, they want to be involved. If they want to be picked, and I think they want to do a good job.
I agree with all that.
Yeah, and I think judges are too quick to try to save jurors and save for causes. Let's get some people on there who are fair, and both sides get a fair shake. Everybody's got bias, and you can't have everybody on the jury in any particular case. So let's go. We've got jury selection. We've covered this well. I'm going to give you a choice here. So we're talking about how we go through the trial. But when we're looking at other parts of the trial, what other parts of the trial would you say are next most important after picking the jury? I mean, we could talk about opening statement or direct exam, cross-exam, final argument. What do you think and why?
I really think opening statement is the next important. I think a lot of people would, argue with me and say it's closing, but I think by the time you get to closing, in my mind, by the time you get to closing, the case is pretty hard baked in most of the jurors' minds.
Yeah,
In fact, I use the closing as an opportunity to just arm the jurors that I think are going to be good for me. Because again, remember, they haven't been given any of the rules of the game. They've just been thrown all these facts.
right.
Now suddenly you get the rules and you're
Now
supposed to
you can
take the
tell them.
facts and apply them to the rules. I mean, it's a tall task. So I am spending almost all of my time saying, I've got to prove this, and here's the evidence. Now, when you go back in that jury room, if somebody says to you, but blah, 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 you remind them, A, this is the law. B, that isn't the correct fact. The correct fact is XYZ, not ABC, right? So I'm trying to give them the arguments that they can make to their fellow jurors, because at the end of the day, I'm not there anymore. I'm done. I hand this baby off to them and trust them with the baby. And I need somebody back there who's advocating for the baby. So I think opening is really the next most important, because it creates this frame through which I'm asking the jury to see the case. If the defense is doing a good job, they're creating an alternate frame. And so it's a battle of this framing. Where are you going to focus your attention? Hopefully most people have seen this, incredible video where it's, like 5 kids and they've got a ball, and the announcer says, count how many times the ball gets passed around. And so you're focused on these kids passing the ball around. In the meantime, a gorilla walks through the scene.
You missed the gorilla.
Why? Because the frame you were given that you saw the world through was balls passing, not gorillas. So that's, in my mind, that's our job on the plaintiff side for sure. It's the job on the defense side too. I wish they weren't sometimes quite as good at it, but it's creating that frame, and so that the jury knows, what's important and what isn't. Maybe if I can give a quick example.
Sure.
Yeah. So I was doing this products case not that long ago, and I knew that the defense very much wanted to talk about how they were just a distributor of a product. They had the same name as the mothership company that was in another country, but then they had USA at the end, right? And so they say, look, the mothership is the one that designs it and manufactures it, and then we just get this thing and we just distribute it. Like it's not and so they keep talking about a design defect. That's, we can't do anything about the design. So I know they want to say that. Now it turns out the law says, I don't care. The law says it doesn't matter where you are in the chain. It does not matter for a design defect.
Right.
So I put that into my frame right up front. Here's one of the things you are not going to have to worry about in this case. You're not going to have to worry about who actually designed this thing. We know who designed it. It was designed in Italy, and then it came to the US. The people sitting here, they say they're just the US people, but they're a wholly owned subsidiary of the mothership. That's what you're going to learn. And you're going to learn that the law says it doesn't matter if it's the wholly owned subsidiary, or it's the manufacturer, or it's the designer, or it's mom and pop shop down the street that gets it from the distributor that resells it. It doesn't matter. So you don't have to worry about that in this case. Here is what you're going to have to worry about, right? So I try to so sometimes the frame is, putting up a couple of black patches and say nothing behind these, because that's a rabbit hole.
Right. So it sounds like what you try to do, and it would make sense, is you're trying to give them a frame in the opening statement that is going to be consistent with the questions they're going to get in their final verdict. And you're trying to help them figure out what's important evidence they're going to hear in their trial.
It's exactly right. I'm basically trying to pre-instruct them on what the elements are without saying these are the elements.
Yeah. You ever get any pushback from judges with that approach?
I haven't yet.
Good.
Yeah. I mean, I'm not quite sure what the argument is. I'm not, I'm not saying this is the law. I'm just saying this is what you're going to need to focus on. Now, certainly there's an implication in there because that's what the law says is important.
Yeah.
But I think, well, I'd like to think that the way in which I do it feels quite helpful to the jurors as an opening statement. And so I think maybe that's why I haven't gotten pushback from judges, because it feels helpful. And I think judges, generally speaking, they don't want to make the jurors' job harder than it has to be. They just sometimes get a little kind of in their own routine. And so they, thinking outside the box can be challenging.
Well, I think that's the danger of the whole system is judges and lawyers, we swim in this ocean, and we got to constantly be thinking about, well, wait a second. What does it look like and sound like and feel like to a juror who's not in this ocean, who's never been in this ocean, doesn't know what's going on in this ocean? How do we make it clear to them? I think you got to always try to get away from all the stuff because you assume everybody knows it, but they don't.
That's right. We get super stuck in the system and forget that we know it and the jurors don't.
Yeah. So, okay, let's talk a little bit about when you're presenting your case with your different witnesses, yours and theirs, lay people and experts. You're going to be dealing with direct exam, cross exam. Do you think one is more important than the other? Do you think they're both equally important? What do you think about that?
I'm not sure that direct exam or cross exam, there's one or the other is more important. I think it has more to do with the witness. So there are plenty of witnesses I put on in direct exam who I feel like are the most important witness. And the same is true of direct exam. I mean, I would say 90-ish, maybe even higher than that % of my cases, my first witness is the defendant. So I'm doing cross exam right out of the gate.
So you're doing 776.
That's right.
Now, one thing I've done a lot of 776 with the defendants to start out. But one thing that can also happen that isn't always as much fun is a defense lawyer, after you're done slicing them up, gets up and starts telling their story in your case in chief. How have you found that to be in your cases?
So, again, it's not a rote thing. It's not, it's always the defendant. So it's going to depend on who that defendant is and what I think, what kind of framing I think I'm going to be able to do that allows me to make the call as to whether I want to do that cross exam right out of the gate. The thing is that jurors will focus on the thing in front of them.
Right.
If it's your client as a plaintiff, that's what they're going to focus on, which is not just the good, it's also going to be the bad.
Yeah.
So I don't want, by and large, my cases aren't, this might sound horrible, it's not meant to be, but my cases really aren't about my clients. They're about the defendants. Yeah. My clients are simply the poor people who were caught in the negligent and sometimes the willful and wanton acts of the defendant. Certainly their life and their harm is relevant to figuring out what the appropriate compensation is going to be. But it's about the bad acts of the defendant.
Right. And you have to persuade the jury of that.
Yeah. And that's why I think putting them on first is a far more effective way to go. And frequently I will follow up the defendant with, if it's the question is one of, accident related, accident recon is important. I'll put on the defendant and I'll immediately put on my accident reconstructionist.
Okay. So let's say you've got the defendant on the stand, you're doing a cross under 776. When you do cross exams, I think of cross as your classic closed cross that everybody's taught in law school. And all trial lawyers will use that tactic, but other trial lawyers like your Jerry Spence's and people similar to that, we had a version of that, although he recently passed away, a great trial lawyer named Milt Silverman down here. And they would do these opening crosses where they don't really care what their answer is. They're kind of telling their side of the case with their questions. So do you use one technique only? Do you use both? And when do you use each type?
I use both.
Mm-hmm.
I would not recommend using both to newer lawyers.
Right.
I think like with, anything, whether it's playing an instrument or a sport or, dancing, whatever it is, math, right? You start with the basics before you start to bring in the more complicated, sort of technically challenging strategies. And
Right.
an open cross is a very technically challenging strategy. It can be incredibly effective. And certainly you can stumble into it as a newer lawyer and it can work out. But as we used to say in the public defender's office, the fact that you won is no indication that you did it right. The fact that you lost is an indication that you clearly did something wrong. So that sounds very negative, but in part that was a coping mechanism, I think, because you get beat and battered so much as a public defender.
Right.
But it really taught me a good lesson, which is to never get too certain that, oh, I did X and we had success, so X works. I'm constantly questioning the things that I do, even when they work, to try and think about them independent of that result, to think about whether that is a good technique to use time and time again.
Right.
I've had good success with the they're not open, and I mean the way I will do the I don't care what your answer is question.
Right.
Those questions are so there's two types of those questions. I think there's the question where yes is helpful and no is even more helpful, because yes is they just admitted something for your case and no is they just denied it and that's patently false. And so now they're a liar, right? So that's one kind of cross, and I think the best kind of cross and the safest kind of cross.
Right.
There's another kind of cross where, isn't it true that blah, blah, blah? No. Isn't it true that blah, blah, blah? No. And after those two things happen, isn't it true that blah, blah, blah? No. They're not giving you the answer you want. You are telling your story, the story that you have the goods for through other witnesses, but this witness is not willing to admit to it. Right. So it's similar to the other one, but it's much more challenging because it requires you to be super focused and not get thrown off your game at all. As soon as you get thrown off your game, you're losing on that one.
Yep.
So I think they can both be effective. I used to teach an evidence course at a law school here in the Bay Area, and I used My Cousin Vinny as the medium through which I taught the course. Yeah. And it's amazing because there's certain things in My Cousin Vinny that are the exact opposite of what you should actually do. So for instance, when he asks questions, he asks a bunch of questions he doesn't know the answer to in presumably cross-examination. You should never do that.
Right.
You should never do that unless it's because you're telling a story like I was just trying to, emulate. On the other hand, he does an amazing job of qualifying an expert witness in Marissa Tomei, which, most people say, oh, that could never happen. It's like, no, that's exactly what would happen in court. And that's probably the result you'd end up with, which is she's qualified as an expert, even though she's just his girlfriend. There'd be other issues that might come up. But I think, the starting point is, you kind of use that Dodd method of cross-exam where it's one fact at a time, you know the answer, you're building a rhythm and a pattern. Once you've got that down and you know how to do that and it's almost autonomic for you, then I think that's the point at which you can feel comfortable to say, okay, I'm going to try some new things in ways that I feel like won't blow the case up. Because there's always this tension between you want to be creative and effective, more effective than you were the last time, but you don't want to do it such that it can tank the whole case because your client's only got that one shot.
But you've got to be strategic throughout, and if you really care about your profession and your craft, you want to constantly learn and grow. You've got to constantly expand your knowledge. Let's go back to that one thing you said, which is common knowledge, and I disagree with it in a limited degree. We're all told, don't ask a question you don't know the answer to. But sometimes that's gold. Do you ever do that?
Um, well, so here's the weird thing. That was my life as a public defender.
Yeah.
I mean, I'm cross-examining based on my gut because I don't have any depositions. All I've got is a police report. And you know who the wiliest, most difficult witnesses on the stand? It's a cop. They are
I'll bet.
professional witnesses. I mean, they go to school regularly on how to testify. So they can, to get them caught in a lie, or to get them caught on a inconsistency, or to try to show that something in their report means X without them turning it into Y. That's really difficult stuff.
Yeah.
And it's hard to teach because there is a little bit of feel to that I'm not sure there's any way you get there except getting bashed over the head a few times because you did it wrong.
Right.
I mean, that's at least how I got there.
Well, here,
So in our civil case,
yeah.
Unless I don't care what the answer is, it is very unusual that I will ask a question that I don't know the answer to.
Well, it should be unusual. In my experience, it should be fairly rare, but my point is there are times to do it. And here's when they are. When you really know your case and you've really prepared, and you've got this witness, you're preparing for your cross of them, and you realize there's a question you might like to ask and you don't know an answer because it was never specifically asked. But if you know the case well enough, if you can be certain that there's no good answer for them, no matter what the answer is, that's when you can ask that kind of a question.
Absolutely. Yeah, no, I mean, that's what I was alluding to earlier is there's some questions where, answer A is good for you and answer B is even better. And you don't know which one it is, and that's okay. So yeah, no, I agree. I agree wholeheartedly.
I mean, I think that's the one exception where you can ask a question where you don't know the answer. It's relatively rare, but I think some lawyers make the mistake of, oh no, I can't ask the question. I don't know the answer. You got to do the analysis.
Right.
And then that may give you gold because, that may be a great point that you're making in the case.
Yeah. I mean, there was like a case I had where, the difference was a bolt. And I asked the guy on the stand, how much does a bolt cost? And I knew that the answer was going to be one of two things. I don't know, which is great. They didn't even bother to look into what the cost would be, or it would be the cost, which I knew couldn't be more than $5. It was probably going to be closer to $1. So either of those was good for me. And
that's a perfect example.
Yeah.
Perfect example. Well, Craig, this has been a great discussion. As I anticipated, it goes by quickly. We have a lot of fun. And thank you so much for helping out today. Now, I'd like to finish off with this. I'd like to have you give some advice. You may have gotten this advice when you were younger. Maybe you've learned it over your career. But if somebody is either never tried a case or just starting to try cases and they want to become a good trial lawyer, what's the advice you would give them?
So I give them two. The first would be go to a job where they have told you unequivocally you're going to get to try cases. And by and large, these days, that's either going to be in a public defender's office or a district attorney's office or something similar to that. And for people who really want to try cases, I still think that's the best path to go. It's where I learned. I clearly have a bias in that regard. But I mean, I tried over 100 cases to verdict before I ever became a plaintiff's attorney.
Yeah.
I mean, there's nowhere else where that could happen that I'm aware of. And one of the greatest attributes that you get as a trial attorney, it's nice to get comfortable in the courtroom and feel like it's home and all of that. That's good. But the more important attribute that you carry with you wherever you go as a trial attorney is the jurors you have seen and talked to. The more people, the more jurors that you see and talk to in a courtroom, the better you get at trying cases,
Yep.
because you learn how to deal with the issues that people bring with them. So first piece of advice would be go somewhere where you can actually get the trial experience you're looking for. The second is, which is kind of related. It was my first day at the public defender's office. I was handed this huge stack of files, and I was told, you have a pretrial conference with Judge Cunningham. This was in Contra Costa County. You need to go down there, and court starts at 9. I said, great. And I looked at my supervisor and I said, what's a pretrial conference? And he said, oh, well, that's where, the DA is going to go through each of these cases, and they'll make you an offer on charges. And then the judge will make you an offer as to sentencing on each case. I said, great, got it. What happens after that? She says, well, then you got to go talk to your clients. I'm like, oh, where are my clients? She goes, well, most of them are going to be in jail. So they'll be in the holding pens. You need to go back and, tell them, what the offer is. So, okay, got it. What if they ask me if it's a good deal? She goes, well, that's a good point. You probably won't know. So, just let them know what it is, and it's their decision. I said, that doesn't feel great. Okay. So I started walking down the street. I run into one of my now longtime buddies and mentors, Oscar Barbara, who's now a chief deputy public defender in Solano County. And he welcomes me, and where are you headed? I'm going to Judge Cunningham's pretrial conference. And I said, I asked about, how I know if it's a good deal or not. And, the boss just said, tell them what it is and let them decide. And he goes, yeah, that's probably the best we can hope for today. He said, I think actually you ought to just kind of go with your gut. You'll have a sense in your gut whether it's a good deal or not. I said, oh, okay, well, that's something more to go on. So I go, anyhow, long story short, probably too late for that. No case settled, because I thought all the deals were terrible. The DUIs, they wanted people to have 2 days in jail. I'm like, 2 days in jail for a DUI? This is crazy. This is back in 1997. And before I made it back to the office, my supervisor, the one who just said, just tell them what it is, had gotten a call from Judge Cunningham saying, who is this kid who is not settling not one case, not a single case got settled today? He's livid. She's like, I'll talk to him. Anyhow, what is the moral of that story? Moral of the story is, if you go with your gut, you end up with a lot of trials. Don't be afraid to buck the system. Don't just because something is standard or normal, you don't have to buy into that. That's other people can buy into that if they want. That can be a guidepost for you if you'd like, but don't be afraid to say, that doesn't seem reasonable to me. That does not seem fair to me. And that's whether you're doing a criminal case, or now when I do, civil cases, people ask me, why do you go to trial so much? I assume in part because I'm not terribly reasonable to the other side, at least in their eyes, right? But I see the world in a particular way for my clients and their cases, and what I think a fair valuation is. That's just sometimes really at odds with the defense. And that's okay. That's why we have courtrooms and juries. Sometimes I'll be right and sometimes I'll be wrong.
Well, that is okay. And there's different worldviews and perspectives. So yeah, trust your gut. I think that's
Trust your gut.
Both things are great advice. Well, Craig, thanks so much for being a guest today. Thanks for all that you do for ABOTA and for your clients. And it's been a real pleasure. And thank you so much for being here today.
Monty, it was really great being with you. I appreciate the opportunity to just have this chat. It's been too long since I've seen you, and it's great to see your face again.
Great to see you too.